This is a part held in the management of Optis Cellular Technology LLC and others Apple Retail UK Ltd.
Mr. Speaker.
I was just picking up on a couple of points from yesterday that I took a bit too quickly. I referred to, this is on the Qualcomm agreement, I referred a couple of times to the judge not deciding the issue, and I gave my lords the reference, but I didn't take you to it. I should have done that, I was intending to. It's paragraphs 263 through to 265, where he identifies what the dispute was, and then at 265 right at the end, so it's on page 379 of the judgment, you see that he's saying he's not deciding. The second issue on the Qualcomm agreement was my lord asked me if it was in the respondent's notice, and we've looked and we don't believe it is.
Just on the first point, I appreciate that you submit that having expressly said he's not going to decide it, it was then inappropriate to use a neutral adjective for the judge then to go on to rely upon the licence in the way that he did.
Yeah.
But is it a ground of appeal of yours that he ought to have decided it and decided it in your favour?
Part of the appeal that he ought to have adopted Qualcomm as a comparable on grounds 2 and 4, yes.
Could he do that if he was entitled not to decide the point that he didn't decide in 265?
Well, not really, my lord. All I was trying to do by that distinction is to point out that our real point on Qualcomm, and where we say he should have decided it, comes in a different ground rather than the one that I was on. I'm not trying to suggest that you can kind of decide it for one and not the other. But I thought my lord was perhaps taking a point about the extent to which we've got it in our grounds of appeal. And we say that the agreements that he should have relied upon in the comparables approach are the Google one and the Qualcomm one.
Yeah.
And your lordship will understand why we say you ought to have decided it for the reasons that we went through yesterday.
Well, this may be a convenient question to ask, and I appreciate you coming on to this later. Since it's in my mind, I apologise, I'll ask it anyway. I perfectly understand why you say that Google is a good company. But can you just briefly summarise, I know you're going to develop it more later, but can you briefly summarise why you say Qualcomm is a good comparable and what it adds from your perspective to Google?
Oh, it's very much a secondary point, my lord. It's just that of all the Apple comparables, it's the only one that isn't tainted by holdout. So it's the best of those, but of course my lord knows it's not on the on the portfolio that we're concerned with. So
well, quite.
So it's not part of my case that it's as good as Google. It's just that of the comparables that he had, there are two that are a lot better than the others, and between those two, my position is Google is the one, and I'm going to. My lord's right.
So you would be content to pin your colours to the mast of Google. You don't need Qualcomm.
I don't need Qualcomm, save for. I'm going to explain why the attack's a bad one, but if you're not with me, there is an attack on the price that one gets from Google, which you could look to Qualcomm to see something that's not as high as the Google price. So I do need Qualcomm as it were, as another agreement that's a good thing to look at if you think the criticisms of Google are good. But I don't as a primary case.
Yeah, understood. Thank you.
Well, that brings me to ground 7, and that's to do with the relative importance of the agreements given in calculating the total price stack, specifically the relative importance as regards varying stack share. And the issue put shortly is that in an exercise to assess what the total or aggregate price for the whole stack is, it's logically indefensible to treat the price paid for tiny fractions of the stack as equally informative as to the price for the overall price as to those which are for substantial fractions. And to do so leads to results that are absurd and certainly not representative of the overall price. And to deal with this point, can I illustrate the issue? And I'm going to explain why it matters and explain how both sides had in fact been doing what we say ought to have been done in the methods that were before the judge. And the point is basically this: if you're seeking to look at data and work out how much an implementer is likely or should be paying for the whole stack, as a matter of logic, you don't take a simple average giving each component the same weight. And can I just illustrate it with a really simple example, much simpler than the situation we have here. Let's assume we've got 5 comparable licenses and they're in fact for a single implementer. Let's not worry whether we're in DPU or lump sum rates. Let's consider the 5 licenses are with different patent holders, and between them they hold 50% of the stack. And let's suggest that the price to be paid to A, who holds 40% of the entire stack, is, say, 40x. We'll keep it simple, we'll say it's £40. Price paid to B, C, D and E, each holding 2.5% of the stack, is a half of x, so 50 pence each. The implementer is in fact paying £42 for 50% of the stack. £40 to A and 4 lots of 50 pence to the other 4. That obviously implies a total for the stack, 100%, of £84. But if you look at it like the judge did, you say, well, the price per 1% as regards A is £1. That's my £40 divided by 40%. The price per 1% for B, C, D and E is 20 pence. That's 50 pence divided by the 2.5%. And the simple unweighted average of those prices per 1% of the stack is just over £0.33. In fact, it's 36 pence. And it's much closer to the 20 pence than the £1 because there are 4 of those going in the average. And if that were the correct way of looking at it, you would consider the price for the whole stack is £36. That's 100 times the price for 1%, 36 pence. But hang on, we know the implementer is in fact paying a total of £40 plus 4 lots of 50 pence, £42, and just for a fraction of the stack, 50%. And that just goes to show the kind of absurd result that you get if you try and scale everything to 1% and then take a simple average. And you get more and more absurd results the more numbers of low-priced agreements with low fractions of the stack that you put in. And can I just point out that implicit in the way that both sides were dealing with this apple pie type argument, which was adding up the price from all the Apple comparables, was to do it correctly, because we were just adding up the price, saying how much of the stack does that represent, and that is, in substance, weighting by stack share. So we were both doing it correctly, but what the judge did was to go to this, we say, absurd way of doing it, which leads to more and more absurd results, the more numbers of low value, small stack share agreements that you have in. And it's just logically indefensible, where what you're actually trying to do is to work out how much the price of the entire stack should be from the agreements that you have, which represent an overall fraction of the stack. Now, what are Apple's answers to this ground? Well, they're set out in their skeleton at power 121 to 125 of their skeleton. And the thrust of the argument is that it was within the judge's power of evaluation. That's the conclusion at the end. And on my reading of these paragraphs, there are in substance 2 points being made. One is a procedural one, to criticise us for not raising this point as a suggested amendment to the draft. That's para 124. And as I understand the way it's put, it's suggested to be an answer to our point, pointing out that what the judge did was inconsistent with the common ground, as I've just drawn attention to. Even if there was something in that suggestion that we should have sought to persuade the judge to change it, that's not an answer to the point that it's logically indefensible in my submission. And in any event, it's not a fair criticism. The judge had completely departed from the parties' approach, including many aspects that were common ground in many ways. This is obviously an appeal point in my submission. So that's the procedural point. The other point, the only one that's purporting to be a point of substance to defend this, is in paragraph 123, as I understand it, where Apple correctly identifies the essence of the point, that agreements covering a larger share of the stack are more informative as to the value of the whole stack, and they assert there's no reason why this should be so. Well, my submission is it's obviously so.
Why does one ever use a weighted average?
Yeah, one is seeking to work out what would be paid for the whole stack. It's obviously more informative to know what's actually being paid for a larger fraction. I can make the same point by asking my lords the rhetorical question. Given the choice, would you like a set of agreements that accounts for 75% of the whole stack, 50% or 2% from which to extrapolate? The answer is obvious.
It might be said, well, this is something where an expert could be expected to have a view as to whether or not one should use a weighting approach or not.
Yeah.
And do you say, well, it was common ground, in effect, that between the experts that one should use some kind of weighting? And then I see in paragraph 124, Apple saying neither of the parties' experts undertook any weighting. So can one see that, in fact, the experts were, in effect, adopting a weighting approach?
Well, that's why I said to my lords that that is in substance what's happening, where you're just adding it up. So what is right is nobody actually said it would be silly to do normalising to 1% and the simple average, because nobody had thought of that. But what was happening for the closest method that we both did, which I've been calling apple pie, which was where they added up all of their DPUs for the Apple comparables, save for Qualcomm. They added them all up, and they added up how much of a fraction of the entire stack that was, and then just extrapolated from that. We did the same with Qualcomm and the submission that I make to my lords is that that is in substance giving each the weighting that is appropriate, because you are not normalising it down to 1% before you average.
Is there a simple reference you can give us in the bundles for where you say that was done?
Where we were doing that.
Yeah, well,
It's coming, and
I see, looking at your skeleton, this might be footnote 113. I'm not sure we get a reference there, do we?
sorry, 100 and...
Footnote, it seems to be sort of footnotes 113, 114, possibly. In footnotes to paragraph 115.
Yes. Yes. Yes, that's the point. But I think my lord wanted
An example. But I don't know whether footnote 114 provides an example.
I'm loath to
Yes.
read out something that they hand up to me, although I'm sure it's right. But I will make sure that I give you that. That's why I explained actually what that case was when I was explaining the cases earlier on. But I make sure that we identify the best reference where you can see that that's what we were doing, both sides. But my lord's right, that reference is to exactly the point that we're on. And we say it's the correct thing to do in logic. And that's really it on ground 7. So that brings me on to ground 8, which is dealt with in our skeleton from paragraph 117. on page 41 of the document 86 of the bundle, and this is the issue of sales volumes. And as I've outlined earlier, the conventional approach, which was common ground between the experts, was when you valuing, you take account of the different volumes that were projected to be made under each agreement. And what the judge did was just ignore that throughout. And as we've seen, he mistakenly thought Apple would advance the valuation case based upon just using lump sums, even rejecting the parties explaining that that was not the case. That's most apparent in that footnote 59 that we've looked at. It's important to point out that this is a point that's a single error of principle that manifests itself in different ways. In other words, there are three different ways that the error impacts on what the judge did. And as we'll come to, Apple's attempt to answer this point is to seek to split the point into three, and they give different answers for each. And a point I've already made yesterday generally applies here. It's not satisfactory to come along to answer a criticism of the judge's approach, to seek after the event to suggest alternative reasons not in the judge's mind as a possible alternative. And that's particularly so where the point has to be split into three with different responses given for each. And as I've already said, both experts were expressing value by extracting a price per unit, whether it be dollar per unit, which in fact both did, or ad valorem, and both were assessed by taking into account sales that were perceived to have been covered. And this common ground included taking into account the materially different levels of sales that would have been contemplated as covered by the different Apple licenses. And of course, different also to the license being settled, which was an Apple license with Qualcomm. And we draw attention to Apple's own expert appendix 6.2a in para 120a of our skeleton, which is page 42 of the document. And can I show you that, please? It's supplementary volume 2, tab 40. And this is Miss Guttridge's table. The numbers are quite small in font size, but what I'm looking for is it's landscape. So if you turn it around, it's just to the left-hand side of the right-hand hole punch, so just a little bit further over than halfway. Right.
It's only up to
My own friend says he can provide A3 if it helps. I don't know whether it's good enough for you.
it's very, very difficult to read.
If A3 is available, then I'm happy to take it.
And I'll just have one copy. Give one to
So that I can read it.
you're not yet over 50.
Right, I need these. So I'm over 50.
So your first copy is gone.
This is Miss Guttridge's table. She always uses flat sales projections. So licenses entered into at about the same time will have precisely the same number for that reason. But what I want to show you is how there is a variation across the group over time. So just picking out the big ones, I'm looking down that column that says estimated annual volumes of cellular units sold, millions of units. So just looking down that column, Huawei is 189. Next one down is Ericsson, 248, so a jump of about a third. Dropping down to Nokia, 7th on the list, that's 228, so a difference of nearly 10%. Qualcomm, I'm not reading out any.
No, you're fine.
Didn't think I was. Qualcomm, line 13 is 215, so about a 15% difference to Ericsson. These are significant variations that each expert was taking account of. So that's just as between the variation of Apple sales in different at different points in time.
Can I just ask you, I see the variation, but I also see some surprising coincidences, which I'm assuming is based on some kind of assumption.
No,
So Ericsson and Grand Mesa, for example, the figures are identical, which at first blush seems rather surprising.
I suspect, I don't know the dates off the top of my head, but that's why I said to my lords at the beginning that because of the way Miss Guttridge did flat projections from a particular point in time, any agreement that's entered into at about the same time will have exactly the same.
Oh, I see.
They're Apple sales projected from a particular point in time. So,
Right, I understand. Thank you.
I mean, I hope that accounts for the ones that you've identified, but there would definitely be some that are spot on for that reason.
Yeah.
We can put that away. The second point I make is that there's obviously an even bigger variation when one considers the Google license that's included in the same way as an annual lump sum without taking account of the very much lower sales volumes covered by it. The judge just treats it as a lump sum payable for access to Optis stack share without regard to volumes of units sold under it. To put it another way, it's as if the pricing it covered any number of units, including the much higher levels that Apple sells. That's the second way the error manifests itself. And there's a third way the error manifests itself, and that's in cross-licensing. Cross-licenses are dealt with in the conventional way by taking account both of the relative size of the counterparty's portfolio and their volume of units. The judge ignores this too. So he's in fact ignoring important variations between the sales volume of the counterparty that you get when you look at the information from the agreement, simply netting off the size of the stack share as we saw yesterday. And that actually is also in a very real way ignoring variations in sales volumes as between the cross-licensed parties, because they're all being used together in the same way without that being taken account of. Now, my lords, failure to take account of this when it's easy to do and common ground in the parties' approaches, is we submit a significant error of principle and logically indefensible. Now, I've identified the three aspects, and Apple has to pick off each of these, how the error affects things in different ways to even begin to answer the issue. And we see that in paragraph 126 of their skeleton. Perhaps we could turn it up. They separate the point into what they say are three complaints, as if they're independent. But the reality is it's one complaint with three effects. And as we shall see, the answers given are just very different in respect of each. If I may, you can see the way they're set out here. Can I take the last of the trilogy set out here, that's Google? Because when we look at that, we'll see that Apple, in fact, doesn't have any answer at all to support the judge. What the judge did in ignoring sales was, as I've explained, to treat the price paid as if it included Google and Apple at the same level of sales. And Apple's attempt to deal with this point is at paragraph 135. And it's basically to mount an attack on the inclusion of Google at all, to suggest it should be removed, as it asserts in the respondent's notice. Now, we can look in vain for any explanation as to how what the judge did is supportable, but there's none. And that, in my submission, my lords, is a very big flag that what he did was unprincipled. His approach was to take a group of licenses, both but not all with Apple, which would have been understood to cover different levels of sales anyway, and which would have covered different cross licenses, and then lump them together with with the Google, and took them all as indicative of an annual fee for a net stack share, regardless of these variations in sales volumes. As I will come to, the essence of Apple's answer on the variation of Apple sales across its licenses is to suggest the kind of variation in Apple sales we've looked at can be ignored as close enough to constant. And the cross-licensing can be ignored because it's generous to Optis. I think the suggestion is that the point, in fact, overall is not something that helps my clients. But that's not borne out by the numbers. Overall, it does matter. And at this stage, what I want to look at is the answer they put forward as regards Google. And it starts at the foot of page 45, para 135. There's a recitation of what the judge said about seeking to price the entire stack to Apple. Desire to be inclusive as possible. Para 136, over the page, advances a point about the high level of Google will unpack, leading to para 137, which is the respondent's notice argument, to remove it. And they go on to say if you did that, change in the stack is small. And in para 138, they go on to deal with our point on the respondent's notice points as to it being perverse to remove the only licence that's actually on the Optis portfolio by suggesting that the licences are fungible. But my lords, this is all directed to the respondent's notice point. The argument attacking the judge's inclusion of Google, there's nothing here at all to seek to support what he did as in any way principled. And the answer is, well, basically we can see it's a big problem, please take it out so the point goes away. And my lords, a short point on the argument that taking Google out makes only a small difference. That's directed to the wrong target. What they're saying is that the number that the judge came to, which we say is wrong, significantly so, doesn't change much if you take Google out. So it leaves you with much the same wrong number. So what, we say? The real point is that correcting for the sales volume error overall does have a significant effect. And of course that involves leaving Google in and doing the correction. And we give, my lords, the overall effect of it at para 120D at the foot of page 42 of the skeleton. They're absolute numbers that were obviously put together before the concession on ground 10 came in. But it gives, my lord, an indication. Broadly, the figure triples, even though the judge's error, for instance, just as to cross-licensing, is something that on its own is generous to Optis. The effect overall is not. And that's because it's wrong, the impression sought to be given by my friends on the other two aspects, that treating Apple sales as constant makes no real difference, and the cross-licensing is generous in our favour. It's not always so, and in any event, when you combine them all together, it is not a generous thing to do. In fact, it's a significant downturn. Those variations in Apple's sales figures are significant, and the adjustment is very significant, with or without Google left in. Now, my lords, I will have more to say about Google and why the judge's decision to rely upon it can't be impugned, and I plan to address the detail of that when addressing the licences that should have formed part of the comparables approach, so when addressing grounds 2 and 4, but everything I say then is relevant to the respondent's noticed argument that Apple raises here to persuade you to remove it, but I'm going to deal with it at that point in my submissions as to why it is actually a very good comparable. So I've got no more to say about ground 8 at this point. That leads to the final error on the judge's own method, ground 9, because ground 10 has been conceded. And that's the judge's treatment of past sales. And we deal with this in paragraph 121 onwards of our skeleton. And the central point here is obviously that what is found is not in fact what happened in past licenses. When seeking to get a price using existing licenses and seeking to take account of past sales, what matters is what in fact happened, not what should have happened if they'd been 100% FRAND compliant. And as I've already explained, both sides recognise this as a feature of real-life licences. My Lords will recall that quote from Mr. Ankenbrandt that I showed you yesterday, which we also refer to in subparagraph 122A of the skeleton, and that's reflected actually in footnote 618. This is page 492 of the judgment. And what I'm looking at here is the point about the difference between simple and future. And it's really right at the end. The key point is the last two lines of the footnote, where the judge is recognising the phenomenon of lower price for past sales. So our point, my Lords, is that the judge was wrong to treat past sales as of equal value when using information from existing licences. The second point that we advance on this is an overlap with the point on ignoring sales volumes, and this is subparagraph B in the skeleton, that even if one thought past sales were priced the same as the future, that can only be at the per unit level. One can't say for the so-called lump sums past and future must be looked at as the same. That will be affected by the units actually covered for those periods of the licence. And there I don't just mean levels of the implementer's sales which may change over time, but details such as whether the licence was in fact a renewal or a partial renewal, points like that which affect whether any release was as a practical matter actually covering significant units not already licensed. So these all bleed into this point in my submission, and Apple's answer is set out in their skeleton at paragraphs 139 onwards. They summarise the judge's approach in 139, and the key point is subparagraph C. They set it out saying that one would expect past releases to be priced at the same as future sales. And they
in the end, that is simply the basis of the judge's decision, isn't it? Because
Yeah.
his previous statistical analysis has fallen away.
Well, it not just he doesn't rely on it. I would say it hasn't fallen away.
Well,
It shows what the right answer
It
is.
doesn't support his conclusion.
Exactly, absolutely right. But the point I'm criticising them about as to the way they put this forward here is that they simply don't recognise that the judge, when referring to what as a matter of principle one would expect in paragraph 485, he actually went on and explained that was not what the evidence showed. And that, having set out what the split was that the evidence suggested, which he recognised was very far from 50-50, decided to stick with 50-50, saying it was called for the reason that he gave at the end of paragraph 485, that it was called for to best disincentivise holdout. And in fact, what's really notable, my Lords, is that they make no attempt to support the judge's reasons at all in these paragraphs. Instead, they seek to construct the argument that the split between past and future was 50-50, or at least there was evidential basis for that, for the judge to conclude it. That's the thrust of the argument here. And it's just misrepresenting what he did and the reasons he actually gave. There are two answers to the way they put this. First, there was no such evidential basis. Indeed, it was all the other way. And the second answer is the judge obviously didn't come to that conclusion, i.e. in fact that it was 50-50, at least not in the judgment he handed down. We know he did think that earlier on a very flawed analysis, which was nowhere near accurate and had to be corrected. But he accepted the correction, and paragraph 485, read fairly, can't sensibly be read in any way that is consistent with the judge having concluded that there was anything like a 50-50 split in fact. And what happens is my friends go back to paragraph 465 little 7 of the judgment on page 472 of the bundle, which was also 4657 in the draft at core 2, page 311. And of course we know that was written when the judge did mistakenly think there was a 50-50 split. And he corrected his judgment elsewhere on the point, but this sentence was overlooked. And it can't on any sensible argument be said he was still, in the judgment handed down, holding that the value attributed to past sales was the same as the future. But that is the thrust of their attempt to support the judge. My Lords, Apple also criticised our suggestion that either the free release unpacking that both of the experts did, the only one that was common, or Mr. Bazant's adjusted unpacking is the right thing to do. This is paragraphs 143 onwards of their skeleton. And my Lords, I don't think I'm being unfair in characterising this argument thus. Look, I can point to ways in which your alternatives are not perfect. Free release may overvalue a bit. I would say not much, and it hardly lies in their mouth to say that, given that their expert only did this. Mr. Bazant's adjusted may not hit the nail completely on the head. I would say, in fact, if anything, it's giving too much credit for past sales. But Apple's argument proceeds from those kinds of criticisms that it doesn't hit the nail perfectly on the head to assert that it's best to go for 50-50. That's paragraph 149, the accumulation of the argument. And that's really it. They don't seek to explain why the criticisms they make of our alternatives mean that 50-50 is better than the alternatives we put forward. And not surprisingly, my Lords, because it's clear they're not.
This may not be a question for you. But why on earth would Ms. Guttridge have valued on a free release basis if she was being instructed that the commercial practice was to pay full value for every past sale?
Well, indeed. That's why I say it doesn't really lie in their mouth. My Lord, what was really going on there is that they were recognising that the reality is Apple did get massive discounts for the past, and they were running a case to start with, trying to say they should have the same here.
Yeah.
They wanted to not pay or to pay a tiny fraction.
Classic stance of the implementer.
Yeah,
There's been delay and I should benefit.
exactly.
To which this court gave a resounding no in Interdigital and Nova.
Yes, but that was after.
Yes.
And so that's what's happened. Anyway, those arguments in my submission are just attempts to pick holes in what we say are a much better way to go, to suggest, well, they're not perfect, to say, well, let's stick with something which is way off the correct way of going. And in my submission, that's not no answer at all. That's the end of drawing the strings together on the grounds. The next passage of my submissions is going to be spending a little bit of time looking at the way in which my Lords make corrections to the judge's method, if you're with me on some of those and think that you can actually correct them. Obviously, that only arises if you're not with me on my primary case, that actually you shouldn't be doing this at all. And it's also subject to my argument as to the legitimate and illegitimate holdout, which we'll be coming on to, because most of these licences are tainted by that. We do recognise that my Lords may feel that there's just too much there for an appellate court to fix, and you may wish to send it back, but we think that there are ways in which you can seek to remedy the errors that I've identified. And what we did to try to assist is prepare a spreadsheet, rather like the one that I understand Mrs. Justice Joanna Smith was provided with in her recent Fran trial. My Lords will have seen that in our skeleton. We referred to it at the end of the individual errors section. And what we actually did there, each section we told you what the effect of that error on its own was, but the spreadsheet obviously allows you to do much more. We provided the other side with the spreadsheet, and I'm happy to say that it actually led to a fairly good degree of agreement. they have engaged cooperatively with its contents, albeit reserving their position to object if I seek to make use of it to support an argument they hadn't anticipated. And we are grateful to them for their engagement on that. In many cases, they agreed the accuracy of what can be seen in our spreadsheet, obviously without prejudice to their contention that my Lord should leave matters as the judge left them. In other areas, they themselves asked us to agree certain calculations, and we were able to respond in a hopefully similarly cooperative spirit, agreeing what we could and pointing out where we didn't accept what they were purporting to show. Another way in which Apple responded positively to our spreadsheet was to flag up points they say were wrong or overlooked. And my Lords will have seen a reference to their responsive letter in their skeleton, which basically incorporates what they say there. And we've responded since that skeleton was filed, and indeed there's been further rounds of letters on either side. Can I show you their initial response, because it's particularly helpful in pointing out 2 points that we're able to address. So my Lords need tab 16 of bundle supplementary 2. And you see at the foot of the first page, specifically as to the correction for grounds 8 and 9, that's the sales volume and past sales point. They raise a point about Mr. Bazant's unpack rates. What they don't mention is that we included Miss Guttridge's unpacking as a spreadsheet choice too, and we'll see that they've 2 points in particular that they raise that we've been able to address. And what they do over the page is they set out their understanding as to how the spreadsheets work as regards the 3 bases of Mr. Bazant's unpack. So that's page 2 of the letter, 57 of the bundle. And what that shows is where the numbers come from with Mr. Bazant's and what they understand the various scalings are. And at the top of the 3rd page, they set out how the overall lump sum is calculated, which is using Miss Guttridge's projected sales as the way of calculating the lump sum. And just to be clear, my Lords, the number they've illustrated at the top of the page is by taking Mr. Bazant's simple unpacking. They don't say why they've picked that, given that Miss Guttridge only did free release. We think it's probably just because it gives them the lowest number, but anyway, they've taken the average DPU from the right-hand side of page 57 at the bottom. You can see that one in bold, and they've used that. You can see that on the right-hand. You can see that they've used that by multiplying the units in the table at the top of page 58 to give the lump sum of $154 million. Now, my Lords, they then follow a series of points said to be from Deloitte, and points 3 and 6 are specific to particular licenses, and are firstly as to the assumed sales volumes covered by Google, as to which we'll see an alternative they present later in the letter. And I'll come to that. I've already foreshadowed that point yesterday as to their suggestion that the number of units is basically double. Secondly, a point as to the actual period of sales covered, and those are straightforward points, and we could look and compare Miss Guttridge's numbers in due course. But the points listed here actually identify 2 more significant points that I need to explain and point out how we've accommodated them. Point 1 is about Mr. Bazant dealing with the cross-licensing in his unpacking using a relative value factor, so that ratio that I explained to my Lords, from PA rather than inography. And although the judge had said he was happy to use Mr. Bazant's unpacking for his ad valorem exercise, which had the PA ratio in it, this is what this point's about. And we think it's a fair point to make, and I'll come on and explain how we dealt with it. Mr. Bazant had unpacked DPUs as well as ad valorem and we'd included DPUs, but the figures that he principally put forward in his evidence did rely upon the PA relative ratio. The equivalent inography derived ratio was available in his evidence in the underlying spreadsheet, and as I'll explain, we've now provided that equivalent too. But that's what the point is that's being raised there, as I understand it. And it actually only makes a significant difference for a license that they mention Huawei. And that's because the sales volumes of Huawei are relatively large, and the way in which PA deals with Huawei compared to Apple is significant in the right direction for that to matter. The other point that they raise is actually, as I understand it, the combined effect of points 2, 3 and 5. And it's this. Mr. Bazant, as I've explained, makes adjustments in his unpacking to projected sales and advance payment of money. It's the point about net present valuing that I mentioned before. And of course, when he did all his evidence, he does that when he's unpacking, and then he does exactly the same when he packs up later. Miss Guttridge had done, well, not done as much detail in that. She had just used simple FRAC projections of sales and had not assumed the same discounts. And the complaint is that you need to adopt the same approach at both ends of the exercise. So unwinding an assumed discount for advance payment of money or uncertainty in the level of units. If you do that in your unpacking, you need to do it again when you pack it up. And so the complaint is, if you're using Mr. Bazant's method of unpacking, you should apply the discounts that he applied for unpacking when you then pack it up. And we've accommodated that too, as I shall show, my lords. But that's the guts of what those points accumulate into, as I understand it. Before we go to look at how we've responded, I should mention that my friend's letter has a series of other calculations and tables that my friends wish to rely upon to support points they want to make. And as I've said, we've sought to engage with that helpfully, even if we disagree with their point. There's just one point I want to highlight that they raise, and it's that point about the Google sales figures being different potentially. If you go to page 63 of the letter, you see what they're putting forward as an alternative number of annual units covered. So 63's got a table, and you see annual Google future sales, and these are just rounded to the nearest million, I think. And you see note 1 says, identifies them using the source Miss Guttridge has used generally, IDC. And the number's basically twice the number. I think we say that it's in fact slightly different. But broadly, it's a factor of 2. It's a helpful point to raise, my lords, because it gives my lords a feel for the degree of movement one would get to the price in the region of dispute as to the best sales figures to use. So Mr. Bazant's unpacking, we know, came out at a particular level that Miss Guttridge was happy to take. But if he'd used different sales figures, you'd know that it'd be about half. So you know that's the scope of the argument. Now, I don't propose to take you through the rest of these further aspects of the letter and our response at this stage, but I do want to walk through our response to their Table A on page 59 and the 2 points that I've just explained. So our response, my lords, is at supplementary tab 4, tab 25, and it has 2 appendices which are at tab 26. And before I get into the detail, can I just pause and make a couple of points? This series of issues that we've been looking at and the effect of them obviously gives rise to a fairly significant number of possible permutations, and it's not possible to set them all out on a piece of paper, but they're available in the spreadsheet which we can make available to my lords just to give you a feel for how easy it is to use, you can see the user interface at tab 29. It's a series of options, most simply with a yes/no, sometimes a question as to whether you want to use Mr. Bazant free release, Miss Guttridge free release, and so on. But it's very simple. And in terms of the possible permutations that we've been able to show in, I hope, a relatively digestible way in tab 26, it's grounds 8 and 9 on the different unpacking bases with other grounds overlaid on top. So that's the first general point I want to make. The second general point I make is this. These issues are not what a scientist would call orthogonal. And by that I mean the effect of a particular ground is not always the same, regardless of whether other errors are being corrected for or not. And it's not just that the size of the change for a particular point might not be the same, but it might not even move in the same direction. It depends what else you're correcting for. But that doesn't mean the issue to which it relates is not logically correct. On the contrary, it is. It's just that it's no part of my case to say that there's an error of principle, but only in circumstances where it moves the dial in my favour. That would be unprincipled. If the point is an error of principle or logic, it remains so whether my lords are accepting other errors such that I'd be better off excluding the point. And what's certainly true is that the overall effect of any combination of errors you identify result in a substantial correction in my client's favour. So can I show my lords what we've done in response to Apple's Table A in their letter? We provided two appendices with the letter. They're A3 sheets at tab 26. And the difference between these is simply this point. What source of data is utilised for the relative portfolio ratio in Mr. Bazant's unpackings for the cross-licensing component? So Miss Guttridge's figures are the same in both appendix, and Mr. Bazant's 3 unpackings, simple, adjusted and free release, vary by that point. And can I take just appendix 2 to talk through as the sheet to talk through, because it's the inography version. So appendix 1 is the one where Mr. Bazant's unpacking uses the PA relative strength ratio, but appendix 2 is the inography version. So we're looking at page 224 in tab 26. And my lords will see a box on the left-hand side is simply the list of the 19 licences with the stack share. So that just identifies the stack shares for each of the 19 licences. There are then a series of 4 blocks of figures moving from left to right. Block 1, as the heading indicates, is using Mr. Bazant's adjusted unpacking. As I say, obviously with inography in this appendix. Block 2 is Mr. Bazant's free release. We've inserted block 2A, which wasn't in their letter, and that's Miss Guttridge's free release. And block 3 is Mr. Bazant's simple. Now each of these blocks is arranged in exactly the same way, so I'm just going to talk through one, and let's take Apple's own unpacking for my illustration, so Miss Guttridge's. Before I do that, just a word about the colours. There's nothing of particular significance to some boxes being white or a different colour. They're just there to help me to orient you. If I had to point to something, it's much easier because it's all confidential, so it's just there for that reason. So looking at block 2A, that block using Apple's own expert, we see the first column is the DPUs that this unpacking gives without scaling to Optis portfolio. There are then 4 columns to the right. All of those are scaled to the Optis portfolio size, and you can see from the labelling, right at the top they're split into 2 pairs. And as you can see from the wording, the first pair, those are the white figures, where licences 6, 12 and 18 are included. Those are the licences subject to ground 5, and the second pair is where they've been excluded. Those are the pair where they've been shaded blue. And so what my lords will appreciate is that moving from the first pair to the second pair results in those 3 licences being excluded. So that's my ground 5 point. Within each of those pairs, as indicated in the wording immediately above, you have either Qualcomm included as that average that you've seen, or included at full value. So that's obviously my ground 6 point. And so the effect of these 4 columns is to set out the figures, firstly without making the adjustment for either ground 5 or 6, secondly when making the adjustment for ground 6, thirdly when making the adjustment for ground 5, and fourthly when making both adjustments for ground 5 and 6, as you move from left to right. If you stay in the white pair, you're leaving the agreements that was common ground were not useful in the assessment. Moving to the blue takes them out, and within those pairs of columns you can choose left or right to do ground 6 adjustments or not. At the bottom of these columns we have 3 rows in bold that give the total, the average and the weighted average. Weighted is by the stack share that's shown on the box on the left hand side. And before we look at the boxes along the bottom where we get to the yellows, oranges and greens, can I just draw attention to a couple of points about the principal blocks 1, 2, 2A and 3. We see for Ericsson itself that as across Mr. Bazant's respective unpackings, adjusted, free release, simple, the numbers increase very modestly from simple to adjusted to free release. It's the 3rd license down. If you look at the block figure in block 3 first, that's simple, so that would be the lowest. It's the same for all 4 columns here. Then block 1, adjusted, as expected, that's the middle one, and we see the same for all 3 columns, and again all 4 columns are the same.
Presumably, Mr. Speck, these numbers are all actually being presented to 2 significant figures, even though in fact the number is actually being calculated to a higher degree of precision when you. So the averages are not the averages of those numbers as written on the page. They're the averages of the actual.
But there's a point on
size.
rounding that they've raised on Friday, but that my lord, I think, is right that these figures in the columns have been presented as 2 significant figures, even though they've been calculated more accurately.
And the averages that are stated underneath are using the more precise numbers.
I think generally that might be so, but I think there is a point that they've raised on Friday night, which means that that needs to be bottomed out.
Okay, well, I'd certainly like to know.
Certainly. Now, on Ericsson, you'll note that Miss Guttridge has a lower figure than any, so that's table 2A, and that's because of the issue that I identified before. And it's not really a free release calculation, and she did the exceptional thing that there was a big issue about following Miss Witt's evidence, the witness who wasn't available for cross-examination. So that's what you can see in the table as regards Ericsson. And that's how you end up with Miss Guttridge putting forward a figure even lower than Mr. Bazant's simple unpacking. Because Apple is claiming that it paid less for the future than those in the past. Now, my lords, the other point to note about these principal blocks before we...
Sorry, can you say that again?
Yeah.
I hadn't quite realised from what you said yesterday that that was the full import of their case. Is it still their case that they should pay less for the future than in the past?
I believe so.
Wow.
Okay. I mean, I'll be corrected if I'm wrong, but they say that Miss Guttridge's unpacking is the right way to approach it, I think. I'll show you the dispute that the judge didn't resolve when we get to Ericsson, but that is what the fight was about, my lord. And that's when maybe I didn't make enough of a meal about it yesterday, but
Okay,
when I said
I've got the point now, thank you.
The other point to note about these principal blocks before we leave them is the entry for Google, and just so that you know, and I think I've said this already, Miss Guttridge never carried out her own unpacking of this, but she did adopt Mr. Bazant's own packing. So as we point out at point 3 in the letter that came with this on page 219, the Google number that we've included is the one that she used from Mr. Bazant. It's Mr. Bazant's free release, so you can see they're the same. Now, just to be absolutely clear, looking at the foot of page 224, the series of boxes where we see the yellow, orange and green colours, what this shows is how each of the overall unpackings stack up as regards the overall lump sum, packed up either with or without Mr. Bazant's discounting. So all of them have taken in Apple's acceptance of ground 10, and the upper line of tables are packed up without the discounting the future sales in the total number. So using Miss Guttridge's sales projections, which is 3.44 billion units. And the lower line of tables does the same using the discounting consistent with Mr. Bazant's unpacking. So the number of units is a bit less shown here. See the text, it says it's 3,347 million. To be absolutely clear, we've shown all 4 principal blocks subject to either approaches to unpacking, but you might consider the top box as adopting the packing up method consistent with Miss Guttridge, so perhaps likely to be used with numbers from block 2A, and the lower boxes are using the approach to packing up consistent with Mr. Bazant's approach. So we put them both there for all of them, but that's the kind of thrust of which one might match up to Miss Guttridge and which one matches up to Mr. Bazant. And what this shows is that if you take block 2A as the way to correct for grounds 8 and 9, but do nothing else, you have the number in the top left yellow box, shown in the row against 8 plus 9, with nothing additional in the column heading. Moving across to the right, the next box also shows the effect of adding in the ground 6 correction, and the next box along, the first light green one, adds in ground 5 but not 6, and the final box, also light green, corrects for 5 and 6 in addition to 8 and 9. And the row beneath basically does the same, but also ground 7 being corrected, as you can see from the left-hand side. And you'll see this is an instance where ground 7 moves the dial in Apple's favour. But as I've said, it's not my case that it only amounts to an error of principle when it helps me. Ground 7 is a particular example of that. In this appendix, where we're only showing a subset of permutations, it actually reduces the lump sum, but in other circumstances it increases the output. And as I say, it's the right thing to do. Now, late on Friday, the point that I just alluded to my Lord Justice Birss, a point on rounding was raised by Apple, and in particular the effect of rounding at different stages in the process. And as I understand it, that obviously can have an effect, and the point that they've raised, as I've understood it, in most instances, if it has an effect, it will be in Apple's favour. But in any event, the rounding must surely be a point that FTI and Deloitte can sort out. That really ought not to be in dispute. It's come in on Friday, and we will address it and make sure that both sides are agreed, or we give my Lord something corrected if there's a couple of figures where there's something wrong. But there's one further point that I should mention on these principal blocks, and it's this. Which one is the best way to correct for grounds 8 and 9 to start with? Because you've got 4 of them. My lords know that free release, the only approach that Miss Guttridge used, errs on the side of generosity to my clients generally. It obviously doesn't for Ericsson for the reasons that we've just touched on, but generally. But subject to those points on Ericsson and indeed Qualcomm, where it's not a true free release, it has a measure of generosity to Optis. But it was Apple's only approach, so it might not be that generous if the discounts given were very heavy. And we pointed out that Mr. Bazant's adjusted might be considered the best way, because that does at least try to apportion some value to the past sales, albeit at reduced rates. Apple in their letter didn't show their own unpacking at all, and they latched onto Mr. Bazant's simple to carry forward for its calculation. That isn't really the right way to correct at all, and perhaps might even be thought not to be correcting properly for ground 9 at all. We present all 4 for my lords, but we do invite particular attention to free release. It was Apple's only approach, so they could hardly criticise it, and also Mr. Bazant's adjusted. Both give, if you look at the DPU weighted average, about the same. I'm looking at the bottom right hand box in the dark blue, right over at the bottom right of each one in dark blue. My lords, that's kind of talking through the basic structure of that. We've also addressed 2 points that have been raised by Apple in this line of correspondence about Google. I've shown you the point they raised about using the higher figure for sales units. They also raised a point about the effect of taking Google out completely, because that's part of their argument. That was point 3 on page 226 in the next tab. I don't think you need to turn it up, but that's for your reference where they raised that. So we responded by also providing the ability in the spreadsheet to remove Google or include it with a price scale to reflect sales numbers from Miss Guttridge's source. That, as I will show you now, is an addition to the spreadsheet functionality. So you can have Google in unpacked with the 2 alternative sales figures, or it can be out completely. When we provided that, what we also did is print out those equivalent packed up figures, so the yellow, orange and green boxes, in the letter that we provided to Apple, and that's at tab 28. Obviously the appendices that I've showed you are using Google in with the Optis sales figure estimates used for unpacking. And what we've done is print out the bottom boxes, the yellow, orange and green equivalents. And we see this on page 229 in tab 28. This is the appendix 1 and appendix 2, so that's the 2 appendices that I've just shown you, equivalent by excluding Google, you can see at the top of the page. And over the page we see the equivalents for appendix 1 and 2, but including Google with the unpacking using IDC sales figures. And that, as I've explained, roughly doubles the sales for Google compared to those in the main appendices. So these are basically appendix 1 and outputs and appendix 2 outputs respectively, but with these additional points accommodated. Now, my lords, it's taken some time to talk through, and it's a consequence of the judge making a significant number of errors. But these points are each points that can make a significant difference to the output, so it is right to look at them. And the spreadsheet itself can
we only get into this if we reject some of your other grounds.
That's true, yes.
This is all on the basis that the judge was at a high level entitled to adopt the approach he did,
Yes.
but that he made one or more of these specific errors in the course of it.
Yeah.
Whereas if he wasn't entitled to go down this road at all, we don't get into this level of detail.
You don't. And also we recognise that there may just be maybe so many points that as an appellate court you feel unable to do that, which means it'll have to go back. But we do think that there are ways in which you can, if you're minded to.
Well, it's been helpful. I'm not suggesting otherwise. Thank you.
But your lordship's absolutely right. If you're with me on my primary points, you don't get into this. There's one other point that I should mention. I was just about to explain that I've obviously not able to illustrate every single permutation. The spreadsheet can do other permutations. It can do any permutation, say for just one, which I need to identify for you. And that's if you try to do a Google adjustment with only ground 10. Don't do that. And that's due to a point on what's involved in ground 10 on its own. The judge did some rounding for his annual fee. So ground 10 just extrapolates to different numbers of years and doesn't go back to the individual information for licenses. So you can't make a Google adjustment with just ground 10 if that's the permutation from grounds 5 to 10. But you can do absolutely anything else.
Mr. Speck, can I've got a question about these spreadsheets that you've just handed up, or you haven't just handed them up. They're the ones that came later, and they're only in the paper. The excluding Google numbers.
Yeah.
I understand the numbers are confidential, but what I'm struck by is that excluding Google seems to make the number. If you look at page 229 and you look at the Bazant free release, for example, just picking that,
Yeah.
and you look at the bottom right-hand number in that block, which is a green number, dark green.
And then, am I in the top?
And take the lower one. So the Apple lump sum royalty using Apple sales per units, including projected 10%. Just taking that as an example.
Appendix 1 or 2?
Appendix 1.
Yeah.
In fact, I think this phenomenon exists in all of them. But the thing I'm interested in is that there's a relatively large difference between the dark green number in the bottom right for Bazant free release and the dark green number for Guttridge free release. Those two numbers are not the same by a reasonably non-trivial amount of money.
Right.
Whereas in the one before that, the two numbers are pretty well identical. And I'm struck by the fact that taking Google out seems to make a much bigger difference, seems to create a distinction between Bazant free release and Guttridge free release. I don't understand why, and I'd be very interested if you could tell me.
I can't stood here, but I will.
Because the way it looks to me, it's not obvious to me, and no doubt it's because I haven't understood it all. And I'm absolutely certain I haven't understood it all, but I mean, I haven't delved into all the detail. But that's a notable thing that taking Google out seems to make. I was very struck by the fact that the numbers with Bazant and Guttridge free release came out at about the same.
Yeah.
And now they don't.
Yeah.
When all you've done is taken out one row.
Yeah. I will get to the bottom of that.
Nice. Well, if there isn't, if it's all very complicated, and you say, well, it's all because of here and there,
Well,
and it goes up and down.
if it's a combination of things, I will just say it's a massive combination of things. Yeah. But it might be that there's one significant thing that's driving it.
Yeah.
And I'll try to see if I can help.
It does look quite striking, I must say.
But I will see if I can get to the bottom of that and perhaps help my lord after a short adjournment. But I'm afraid stood here I can't off the top of my head. That's all I was going to say on that and how you can seek to correct the errors on the judge's own method. I was going to turn to the rather thorny issue of legitimate and illegitimate holdout next, which is quite a significant topic. And it's actually an issue that overarches the Apple comparables and actually affects the judge's own method because he relied upon basically Apple comparables. And specifically the reason this matters is the body of Apple licenses have been secured pursuant to the strategy that we will be looking at. And we will look more closely at the spread and we'll see the spread in the data itself. And we say you actually see the effect in the spread of the data is a manifestation of the different size of the holdout effect on different types of counterparties.
Now, I appreciate this is an important grounds of appeal for you, but can I ask a rather naive question, which is, suppose we came to the conclusion after mature reflection that the Apple comparables are not comparable for the very simple reason that they're not concerned with the relevant portfolio. End of. If we came to that conclusion, would any of this matter?
Probably not. If what you're suggesting to me is that the conclusion would be just Google.
Well, the conclusion would be in two parts. First of all, to be comparable, it must be a license of the relevant portfolio, and that excludes Apple straight away. And then, what do you have an acceptable license that's representative for the relevant portfolio, and the only one that's in the frame is Google.
At that level, I agree with my lord. I would anticipate that what we might still get from the other side is, when looking at whether Google can be used, you should be looking at, for instance, what kind of information you could get from the entire stack from the Apple licenses. They might run an argument like that.
Okay.
Don't want to encourage them to do so, but I certainly don't want to sit down and not deal with. This is quite an important topic.
No, well, I prefaced my question by making it clear that it's premised upon a conclusion which we've not yet reached.
Of course. But even if you were to do so, I can still see that there might be squabbles about the conclusion you should come to about the level that you can see in Google. And they might be relying upon Apple licenses, so that would be relevant to this. And it really matters, certainly on the way we're arguing about which licenses you should look at and the judge's approach, because, for instance, implicit in Apple's criticism of my client's reliance on their Qualcomm deal as the only good Apple license, if any Apple license can be used at all, the argument is that the Qualcomm deal is non-frand and an outlier, and that relies upon the suggestion that the others in the body are unaffected by holdout. And we say it's the opposite. And so, for instance, if we look at the judge's table 13 on 489, 489 of the bundle. So just looking at the way he was dealing with it, but with these annual fees. So it's on his method, which I obviously say is wrong, but it can illustrate my point. Apart from Google, they're all Apple licenses. And if you look at the judge's preferred averages, so AV3, I'm not going to read them out, but if you cast your eye down that column, we ask forensically, what is it that explains the size of the difference, first of all, between Qualcomm and Ericsson? Apple say Qualcomm's an outlier, procured by hold-up, we disagree. But if it be so, look at the multiplier. You can just see by eyeballing it. Say, look again between Ericsson and the next one down into digital. And then run your eye down all the way to Pantech. What is it that explains the spread of this magnitude, my lords? Well, it's the conduct that we're going to be looking at. And to be clear, the judge's primary findings of fact as to what they in fact do in negotiations is, in my submission, holdout, and it's of the most pernicious kind. His error was to consider that there's this dichotomy between legitimate and illegitimate holdout, and that holdout is prima facie legitimate. Saw it in that heading that I showed you yesterday. And underlying that, I think, is because it's not as such unlawful. And additionally, we'll see that he also appears to be influenced by timing of the Unwired Planet Supreme Court judgment as to conduct which might not have been illegitimate when it would be afterwards. All of that is unsupportable in my submission. And as a starting point, can I just remind my lords of a couple of key points from the authorities, in fact just one. For this purpose, can we please look at Lord Kitchen's judgment in Unwired Planet? So in this court, that's Authorities Bundle 4, tab 2. And if I may, I just want to highlight two crucial points on hold-up that are linked. The first is paragraph 54 on page 205 of the bundle.
Can you just explain to me, why are we looking at the Court of Appeal on this point?
Because there's some detail in it which is important for holdout, which you don't get in the Supreme Court.
All right.
It's consistent with this, what the Supreme Court say, but it's some detail that helps, my lords, for some specifics.
And I missed your paragraph or page reference.
Sorry, it's page 205,
Yep.
para 54,
And this is in the context of a discussion of the need to ensure SEP holders can stop users free riding on their innovations. And the point I'd ask my lords to note is the statement at the end of paragraph 54. It is important that implementers, where necessary, agree to submit to the outcome of an appropriate FRAN determination. And page 213, paragraph 88. This is the well-known passage identifying the patent by patent, country by country approach as a blueprint for holdout, specifically about 5 lines from the end of the paragraph. So 213, about 5 lines from the end of paragraph 88. While we've got it out, to save us getting it out again, can I also ask my lords to note paragraph 125 on page 220, which is, and over the page there as well. It's another important point that's not bang on for what I'm on now, but it will save me coming back. The point is that where more than one thing is FRAN'd, the SEP owner can choose. So that I'll be coming back to later on a different topic. But the two that I've just shown you first are bang on what we need to have in mind when we look at what Apple's doing. We can put that away now. And before we look at the detail, can I just make sure you know what the thrust of Apple's argument is and why it's wrong? They seek to say all that Apple do, and all the judge found that they do, is to suggest they might review some patents individually to assess the quality of the portfolio in advance of negotiating a portfolio license. They contrast that to a licensee taking a position that it will require prospective licensors to litigate patent by patent, which is the blueprint for holdout strategy that we've just seen. And Apple seeks to suggest that the judge's findings of fact are simply the former and not the latter. Although, as we will see, that is obviously not how they understood the findings when they strained every sinew to get him to change them. Just to be absolutely clear, so I understand the argument, they don't seek to argue the latter is not holdout, nor could they given the passages in Unwide Planet I've just shown you. The whole thrust of the argument is to try to say that the findings of fact do not amount to that conduct, when it's quite plain, as I shall show you, that they do. And this will take a little while. Can I start in the judgment at paragraph 201? It is part of the judgment addressing Apple's approach to negotiation licenses. That starts on page 337 of the bundle. That's where the section starts. The first bit I want to pick up is paragraph 202 on page 340, which refers to a letter sent by Apple to Etsy in November 2011. It is, even now, or certainly last week, still displayed on their website. And my Lord sees its introductory text is quoted in the body of 202, culminating that Apple is committed to licensing frameworks for cellular standard essential patents based upon 3 basic elements: appropriate royalty, common royalty, and no injunction. And then the judge set out verbatim the text of the letter that followed on each. And we see at para 203, the judge concluded that my client's characterisation of Apple's approach to an appropriate rate being reflective of the party's portfolio actually constituted patent by patent licensing, and that was not an unfair characterisation. That's an important finding, and my lords will see why he said that, but I invite you to note it here. It's not how Apple would have it now before my lords, namely simply inserting a desire to conduct a patent by patent review in advance of licensing portfolios, this is actually licensing patent by patent. And as we shall see, they know full well that means the patent owner has no way to break the deadlock, which is why it's a blueprint for holdout. If we go over the page to page 341, we see that the judge sets out large parts, not quite all, but large parts of Apple's statement on FRAND licensing of SEPs. That was exhibited to Miss Mew's evidence. It was displayed prominently on Apple's website, and in fact also remains the case even now. Let's pick it up just below halfway on page 341 of the bundle, the last bullet point, so just above the heading merits-based evaluation. Look at that. That bullet refers to parties' fundamental right of access to national courts, and a willing licensee does not become unwilling if it refuses arbitration, and then this, or challenges the merits or resorts to litigation because the SEP owner does not offer FRAND terms. We will see what is meant by Apple saying that there should be access to the courts to challenge the merits. The next section of bullets begins by stating that traditional patent law burdens of proof should be applied to test the merits of SEP owners' patents and royalty demands, just as they are for all patents. And the bullets flesh this out. The first says SEP owners should not avoid or shift traditional burdens. The next is key. The SEP owner should identify each SEP to be licensed and should prove with specificity why each is actually essentially fringed and not otherwise invalid, exhausted, licensed or unenforceable. This is the traditional patent law burden on all these matters to be applied to each and every patent to be licensed, my lords. The third point is as to also proving value of each and every patent. So it all has to be done patent by patent. The next section at the foot of the page is also absolutely key. Its heading is Portfolio Licensing, Unbundling or Tying of SEPs. And the text beneath it states that no licensor of any type of patent, including SEPs, has a special legal right to collect royalties for only a portfolio-wide license. SEP licensees should not be forced to take bundles of portfolio licenses, all portfolio licenses. So that's reiterating an implementer can choose patent by patent for its licensing. It's obviously not simply saying an assessment of the value of the portfolio license can require the implementer to review some patents one by one as a preliminary.
The use of the word bundling suggests a kind of contention that portfolio licensing is anti-competitive.
Sure.
Is that articulated anywhere?
Well, the thrust of their policy is that they ought not to be forced to do it. So
That's different.
I understand. I don't.
That's simply, we don't want to do it.
Yeah.
What I was asking for, is there an articulation of a coherent argument that portfolio licensing is anti-competitive?
I don't think so. But my friend will point to it if there is.
Right.
In this section, the point is most clearly seen in the third bullet point at the top of page 342. SEP licensors should not demand that a SEP license take a portfolio or bundled patent license, whether all included patents are declared SEPs or a combination. It's absolutely clear. Even if it's just SEPs, they're not having it. They are saying there should be no demand for licensing by portfolio, even when they're all declared SEPs. And the point is rather reinforced by the first bullet here in this section. If you cast your eye back up, the implementer should be able to choose whether to license individual patents or a group or the entire portfolio. This is not...
Where was that, Mr.
Right at the top of the page, sorry. I dropped down to the third one. And the first group of three...
Oh, I see. You should choose, yes.
Yeah. So it's right at the top of the page. Again, my lords, this is not, as my friends seek to argue, reviewing some patents individually as a precursor to a portfolio license being negotiated and taken. Can I move, before we move to the next section, show you Apple know full well this is a blueprint for holdout, because unless they agree a deal, the SEP owner cannot actually force the matter to a resolution. For that you need supplemental 5, tab 10, this is me cross-examining Miss Muse on this section of this document. We see it starts at page 699. So I'm over the page actually, on page 36. 699 of the manuscript is where it starts. Foot of the page right through 700 into the top of page 701. And the key bit is down to the answer at line 9, where she accepts there is no way of forcing the matter other than pattern by pattern. Answer, that is right as a legal matter.
Sorry, that answer you just read, can you direct me to it again?
Yeah, I'm sorry, it's page 701,
Yeah.
line 9. So the whole thrust of the cross-examination
Yeah.
starts at 699, but the key
Alright.
bit is down to that question and answer at line 9.
Thank you.
Returning to the judgment, page 342 of the bundle, the next section of the Fran statement is entitled Fran royalty base, and we see it's Apple's contention the royalty should be paid on small components, usually that SSPPU argument, typically the chipset argument. And the final section at the foot of page 342 and over the page is directed to no injunctions, or they're being very rare. Rather optimistically claiming in the second bullet point that monetary damages are a sufficient remedy. It's really hard to see how that can be said to be a tenable view now. Indeed, the whole thrust of this policy has been comprehensively debunked by the Supreme Court decision in Unwired Planet.
So the threat of an injunction on even a single set creates hold up.
Yeah. And I'm sure my
How
lord,
does the set owner ever get a licence
they don't.
if they can't threaten an injunction?
They don't. What a shame. And my lords, I think, know that Apple intervened in the Supreme Court hearing. My learned friend drafted some submissions which sought to support policies like this. This whole policy in my submission has been comprehensively debunked by the Supreme Court in Unwired Planet. We see in the bullets over the page that Apple says that an injunction should only be available when a set licensee, so an implementer, fails to comply with the final judgment, is bankrupt or beyond the jurisdiction. The effect of that first limb, with the earlier contention that you should only get damages, is obviously you don't get an injunction if the implementer pays national damages under patents they've been found to infringe. That's obviously territory by territory, patent by patent. Not even patent by patent licensing, it's patent by patent litigation with the implementers simply paying damages as they go. There's never been any prospect of an injunction or proper recompense. And as the passage I've just shown you in the cross-examination that I referred to shows, they know it. There were other key documents pertaining to these matters covered in the evidence before the judge, which he didn't address in his judgment. Can I show you a couple of them, please? They're important in themselves, and also to understand some of the extracts of the transcript that the judge did set out. The first of them is a slide deck that shows Apple's strategy from February 2014 at Volume 2, Tab 2. That's Tab 21. We still have the old trial marking as confidential. I cross-examined in open court on this at trial without reading any specific numbers out. I hope I'm not going to upset Mr. Nicholson by referring to it again.
My lords, I have a very comprehensive analysis of what was improperly read out at first instance and has therefore entered the public domain. These are still restricted confidential, and my learned friend can't seek to make more public than has already been wrongly made public. So he needs to be very careful with these slides.
I can well understand why they don't want people to know about this. And if we have to, I'm not going to refer to anything that I don't think I referred to before, but I don't know what my friend says I shouldn't be referring to. If we have to go into private, I'd ask my lords to go into private.
Well, let's see.
Can we see how we go from here?
Certainly. We can see the title is Cellular Set Licensing Update.
Sorry, I must be looking at the wrong thing. Where should I be looking?
You should be in tab 21 of supplementary.
Tab
bundles.
21. I was indeed in the wrong tab.
You should have, it's a slide deck, my lord.
Yes.
And the front page is Cellular Set Licensing Update. And we see item 1 on the agenda on page 90 is an overview of cellular IP strategy. That item is on page 91 of the bundle. And we see in that overview the heading is Reshaping FRAND. That, my lords, is the strategy. Apple's strategy is to change what we consider willing licensors and licensees would agree. And the first item, so the first box on the left-hand side is labelled D-value SEPs. That's the first thing mentioned as part of the Reshaping FRAND strategy. Apple's aim is to devalue SEPs. And within that subtopic, so the detail on the right-hand side, we see first royalty base. That means what they pay the royalty on. It's the SSPPU argument. We see the target is to use the baseband. That's baseband chip. So royalties on something that's a tiny fraction of the value of the phone. And we also see within this a desire to control for over-declaration, although that's notably not the approach taken here vis-à-vis my clients. They want to dilute my share with the totality of all declared SEPs. The final bullet is to build favourable arm's-length comp licences. And we'll see that theme repeated. Elsewhere it's called licensing opportunistically. It's filtering the deals to be done, picking and choosing who to do a deal with to have a body of favourable comps. Perhaps particularly notable given the allegation levelled against my clients of doing that because the smaller licensees had signed up sooner than others. The second limb to this Reshaping FRAND strategy is to limit injunctions. We see from the detail given that the point is to make it so that they would be very rare, echoing what we've already seen set out in the judgment from that other document. Note this is coupled here with something else we've already seen, a contention that a refusal to arbitrate a portfolio FRAND rate should be viewed as not unwilling, i.e. a perfectly acceptable course to take. To be absolutely clear, that's avoiding submitting to an appropriate FRAND determination. The third limb has the overall heading Resolve Efficiently. This has within it bullet points directed to meeting traditional burdens, validity and infringement. We've seen that what that already means. It's a point as having to do that for every patent upon which you're to be paid. Can we move on and pick this up at page 95 of the bundle? Apple identifies a range of approaches it can take to licensing and the pros and cons in its view of each. It identifies 3 licensing strategies, but we'll see one is far left, one is far right, and the other one displaced right over towards the right-hand side. So one on either extreme, and the third one is close to and positioned towards the right-hand extreme one, illustrating it's closer to that than the approach showed on the opposite side. Can I just look at these strategies one by one with my lords? The one isolated out on the left is broadly licensed with willing entities. You might have thought that was what a willing licensee would do, and that was the end of it. And I'll come to it, but Miss Muse struggled in cross-examination on this. She rather surprisingly sought to argue this was a strategy where Apple would be paying over what was FRAND. Anyway, we see the pros and cons of doing this thing, generally taking a licence with willing entities in Apple's views. The pros, reduce litigation burden, obviously because being willing to license with willing entities means you have very many fewer disputes. They also say more control over rates, and that's how I understood it, because the opposite side includes adjudication, i.e. a court imposing terms. Let's look at the cons. Paying ahead of the market, a reference to others not paying as soon as Apple if you generally take licence with willing entities. We will see delaying payments is thought by Apple to be a pro on the other side of the diagram. The other con is a large defined cost. It will be more expensive to broadly license with willing entities because you're actually paying them. Can we look at the far right next, license as adjudicated? So this is only licensed when there's an adjudication, and the upside in Apple's view is you can force proof of patent merit and value. That's referring to patent by patent, but they also say here that you can delay payments and possibly reduce them. So it's going to be cheaper. The cons are the litigation burden, loss or increased rate exposure, and an injunction exposure as a unwilling licensee. So, my lords, you have a more nuanced third approach, tucked up close to the licence as adjudicated, but placed a little to the left, and it's called licence opportunistically. And the idea is not to be so far over as to only license when adjudicated. You're close to that, but you opportunistically agree to take licenses. So as for the cons, there's an element of paying ahead of the market, still litigation burden because one's only licensing on the occasions you see a favourable opportunity, and you still have loss or increased rate exposure. Those last two cons are the same as the licence as adjudicated, because you're still going to have a significant litigation or a significant number of cases where that's what you do. Basically the opportunities that you don't like and choose to take a licence. And the pros of licensing opportunistically is what Apple would establish itself as a willing licensee. The point seems to be Apple can tell people it's willing because it has licenses. One assumes the idea is not to tell people they're only the opportunistic cases though, but that seems to be the point. And the second pro is to establish rates for use in policy setting and negotiations and in litigation. So the thrust is pick those cases where you can get a rate that you want to be able to use later in those other situations. Lords, there's a second internal Apple slide deck explored in the evidence. That's from May 2015. That's in Sup 2 tab 27. It's an internal presentation of Apple's IP and licensing strategy made by B.J. Watrous, the individual who wrote the famous Apple letter to Etsy and whose signature we see on many of the negotiation letters. It's an internal presentation for Apple's Chief Financial Officer. And the part of this I want to show you is the section called Creating Evidence and Savings. So it's tab 27, page 157. And you see the heading, introductory slide to this section on page 157, and the next slide has the heading Deal Flow Pipeline, using liabilities as an asset. And the third point down on the right hand side says this: we selectively filter this pipeline to identify the most desirable deals. And then they go on, and the subsequent slides explain what they're looking for of doing this. And the essence of this is the license opportunistically approach. And that's obviously why the heading of this section was creating evidence. You're doing exactly what we saw earlier, establishing Apple as a willing licensee and establishing rates that can be used later. Now, the judge didn't refer to any of the material in the two slide decks I've shown you in his analysis of Apple's strategy, even though Miss Muse was cross-examined extensively on that, and we placed heavy reliance on it in our closing. I want, if I may, just to show you an extract from our closing on this, because Apple suggested that our Annex 3 to the skeleton is selective, and it's not. We obviously had to limit what we covered in the appeal skeleton, but it's completely typical. Would my lords please take up supplementary bundle 4, turn to tab 4. These are extracts from our closing. I'm afraid it's not the only place we have extracts from that document, because of the way that they came in, some as a later response to my friend's skeleton. And I'll show you some other parts of it in a different place in the bundle. But here we've got the contents page of that closing to start with. And at the top of that contents page, you see there's an introductory section on Apple and its conduct. So that's right at the top under overview. And at the foot of the page, you see we had a significant further section on Apple's strategy, which has 3 subtopics, and the first of these passages is actually in this section, and the other is in the other section. So I want to show you the first, if I may. So it's this bundle, page 35 to 47. It's obviously too much to read everything now, but I do invite my lords to spend some time to see the nature of the case. Can I just pick out a few highlights? Paragraph 10 addresses the fact that the policy, that's the statement the judge quoted, most of at paragraph 204 onwards, was drafted in the run-up to Apple's intervention in the Unwide Planet Supreme Court, supporting patent by patent. And you see the essence of the answer in the extract of cross-examination at the foot of page 35. Miss Muse says Apple respects this jurisdiction, but it's just one jurisdiction. It is still their policy. In response to my suggestion they've carried on regardless brazenly, she confirms it remains their policy. Page 37 and page 38 deal with pages of that first slide deck we looked at. On page 37 we address the explanation Miss Muse gave that the devaluing SEP's limb of the reshaping Fran strategy was better thought of as contributing to the goal of appropriately valuing SEPs. That's the way she sought to explain that away. On the next page, we address the licence opportunistically slide that you see set out there, and Miss Muse struggled to suggest that the left-hand side, broadly licensed with willing entities, in fact results in overpaying. Over the page 39, we deal with Miss Muse's attempts to deal with the obvious point that licensing opportunistically was being suggested as a way to give the impression of being a willing licensee while not actually being one. And she struggled to give a coherent answer to what licensing opportunistically meant, and we set out the transcript. The suggestion she made, completely untenably, was that you license when you can. My lords, please look specifically at the last question and answer in that passage set out between the hole punches. My submission is it is not unfair to describe that as incoherent. We also draw attention to the attempt to claim all 3 of these approaches as willing licensee approaches. That's paragraph 21 in the extracts referred to there. Do note, my lords, this is a claim that even the license when adjudicated approach is the willing licensee approach. The passage at the foot of page 40 and over the page deals with the second slide deck that we looked at, and an attempt to explain away the parts of the documents that were plainly suggesting the aim was to selectively filter to pick an opportunity to create evidence. The thrust of the answers that we set out on page 42 was that it was simply saying that they are licensing willingly. Untenable in my submission. At page 44, we address the strategy of seeking to enforce the ETSI undertaking to avoid an injunction, but seeking also to avoid being committed to the dispute over Fran being resolved, or at least having to accept the outcome. That was obviously something that has played a particular key role in these proceedings, and in particular it was the whole point of trial F. And we point at paragraph 32 on page
you referred to that yesterday, and I of course understand full well by what you mean by that. I don't think you should assume that both of my lords are equally fully up to speed with that. So you may need to briefly show them that.
Well, I was going to refer to what happens, or what Mr. Justice Mead said about it, which is quite an important thing.
All right.
I will try to elaborate.
Take your own course. All I'm saying is it shouldn't be assumed that everybody knows everything.
No, I understand. Well, let me start by referring to what Mr. Justice Mead did or said. We point at paragraph 32 here on page 44 to a striking aspect in this case, and this is a point that was made by Mr. Justice Mead. There was not another place the dispute might be resolved. Apple was fighting to be able to reject the outcome, and the reason that it's important that what Mr. Justice Mead said is because sometimes one gets a fight which is basically a jurisdiction fight, a fight that you should have the case determined in America, not here, and that may be a legitimate fight. But what's absolutely crucial when you're holding out is that you're trying to avoid having it resolved, and certainly trying to avoid committing to it. And just actually to perhaps deal with the point that my lord suggested, the guts of what they were trying to do in the trial F case was to say they can both resist an injunction, but also resist committing to a Fran determination at all points before it's been finally determined. And then later on, having resisted it for years, say that they're deciding that they don't want to take it. So that you, after years of litigation, get nothing more than damages here for 1 or 2 patents, and then you have to try somewhere else to enforce. And in fact, that's an important context that will help my lords to understand the American proceedings issue that I'll come to tomorrow morning. It's how we got there because of the stance they were taking. But that's what they were doing. And they were fighting hard to be able to reject the outcome. And they were, I think, basically saying the same thing that we saw them say about why they didn't accept the American court decision, or an American court decision in the Qualcomm dispute. You'll remember that I showed you footnote 5 yesterday, and the explanation was, well, we might not like the outcome. It's the same thing. And my Lord Justice Arnold will recall adding a postscript to your judgment in trial F.
Well, why don't we have a quick look at it? I think it always does help for those who haven't seen it before to have a little look.
Well, the postscript in particular is illuminating.
So this is authorities 2.
So we ought to go.
3, I'm sorry, tab 2.
We ought to go to authorities tab 2, but we still need supplemental 4.
Yes, you do.
Yeah.
I'm not sure it is authorities 2, is it?
3 tab 2.
I don't know whether my lord had other aspects of the judgment in mind, but what I particularly had in mind was the postscript that you added on page 117. And I'm going to be coming on to the particular, well, in fact, I'll say it now, but I'll probably say it again because it's in my note. Your lordship indicated that what they've been doing in this action may well amount to holdout. But it would be for the trial E judge to decide that, and that's Mr. Justice Marcus Smith. But he never did. And that's regrettable because that would have shed light on the rest of their conduct in my submission. But what your lordship is pointing to is the real problem that SEP owners have where implementers behave like this, and that the behaviour in this litigation by Apple may well have amounted to holdout, and you're anticipating the trial judge turning his mind to that and deciding whether or not it was. But he never did. And that's not because I didn't ask about it, because in fact that's the very next bit that I was going to show you in our closing. I asked Miss Muse about the strategy. This is para 33 on page 44. So immediately after the extract of Mr. Justice Mead pointing to the peculiarity that they were basically saying they wouldn't accept it even though there was nowhere else it would be determined, I asked Miss Muse about that. She was unable to explain, saying she had no knowledge. That's para 33 on page 44. Relatedly, paragraph 34 and 35 of the closing is Miss Muse disagreeing that it was important to avoid hold-up for an implementer to submit to an appropriate FRAN determination. See in particular the end of the extract that we set out at the top of 45, page 45. As we point out at paragraph 35, what she was suggesting was precisely, what I was suggesting to her was precisely what Lord Kitchen said was important in Unwire the Planet in this court, and you see from that answer, Apple disagree. It's rather crucial, and it's something the judge lost sight of, holding in effect that it's all fine and dandy avoiding doing this in a hard-fought negotiation. And also the last topic covered here, this is paragraphs 38 and 39 on page 46, is a point positively pleaded by Apple, and it's that they knock the price down if the SEP owner has a, quotes, preparedness to accept lower. Let me show you that in the pleading. It's Apple's position statement in Core 3, tab 3, page 73. And there's a list of things that are said to tend to support a lower set royalty. I'm on page 73, and we see number 5 in the list is a preparedness to drop the level of licensing demands. As pleaded here, it's linked to a downturn in licensors' economic fortunes, leading to that preparedness, and only here specifically said to be applicable to one confidential at that stage. I'm not going to read out who it is, in case it still is. But of course the point is, if a licensor has, or perhaps more significantly can be made to have, this preparedness, Apple will obviously be taking advantage of it.
Yeah, well, the argument is that a less economically powerful set owner gets less than a more powerful set owner.
Indeed. That's what you see the spread in the table I showed
How
you.
that's framed, I will be interested to hear in due course.
Yes, but that is exactly what you see in the spread in that table that I was pointing my lords to. My lords, we had a further important section in this document, this closing, that covered some of these matters in a little greater detail, but also looked at the negotiations that we'd received disclosure in respect of. And that extract was in fact already in the bundles at supplementary 1. So can I ask my lords to go there now? And put supplementary 4 away. And need supplementary 1, tab 3. It's the same document, but unfortunately it came in 2 tranches. And can you go to page 26 of the bundle? Which is the extract on page 62 of the document. And the first few pages here cover similar material to what we've been looking at in the overview part of the closing, but it moves on at page 34 to go through the detail of how Apple has behaved in negotiations with third parties. And there are 8 pages covering these matters, and even this is picking out highlights. We've got chapter and verse in an annex to the closing, which for your note is actually the next tab to this in this bundle. And our annex to our appeal skeleton closely based upon that material for just one specific SEP owner as an example. But the 8 pages that we have in tab 3, pages 34 onwards, cover topics such as Apple consistently asserting every single patent for which claim charts are provided is not needed to be licensed as either not essential or invalid. That is from para 212 on page 36. I won't read out, we give an example in para 213, I won't read out who it was, but hundreds of claim charts were sent, 50 picked at random in 5 waves. They all get the same treatment. The point of this, my lords, is what we say in paragraph 214. It's because at the same time they're saying they can force licensors to litigate patent by patent. They're doing precisely what's been identified as a blueprint for holdout. And this section of the closing also deals with the point advanced below, and which I think might be being addressed before my lords, and it's this. You see paragraph 222D at the foot of page 40. The argument from Apple is, look, don't worry, we might say and do these things that you're complaining about, but we also make substantial offers for portfolio licenses. So it can't be holdout because we do license deals, and the deals aren't patent by patent. That, of course, is to ignore the point of this conduct. It's to soften up the other side, wear them down, you might say, put them in a position where they'll accept much less than it. If, for example, Apple had simply said, look, we disagree as to the money, we accept we need a license and we can continue to negotiate, but we'll submit to a suitable FRAN determination for a license of your portfolio. But they don't do that. They bend over backwards not to do that. Now, well, that's an end of the detour into those additional materials that played a prominent role at trial. Can we turn back to the judgment, please? We were at paragraph 205. This is the judge referring to Apple's statement on FRAN licensing of SEPs that he'd set out. He notes that Apple defended it at trial and continued to defend it, and we've seen aspects of that in the further materials that I've shown you. Paragraph 206 is important because the judge specifically turns to what he described as Apple defending the right of any licensee to insist on a patent-by-patent review of any patent in a SEP portfolio, if that was what the prospective licensee wanted. Just pausing here, the reason this passage is particularly important is because of the distinction my friend now seeks to draw between a patent-by-patent review as a precursor to a portfolio license negotiation, between that and a patent-by-patent review as part of the stance that they can take a license to patents one by one. And my friends, as I've said, are seeking to say patent-by-patent review is not patent-by-patent licensing. But we can see by the next sentence, this is not what the judge is talking about. He specifically says this. In other words, no licensee could be compelled to take a portfolio license if it did not wish to. it's precisely the point we've been seeing in Apple's materials, a patent by patent licensing stance. I, Apple, can choose to take a license one by one. I, Apple, choose whether I need a license on any patent, and I, Apple, tell you which ones I pay for. That's the essence of it. And as an aside, we've already seen a little bit of it, but we'll see more. Apple simultaneously goes through each patent put forward, and always, and I mean in absolutely every instance, comes to the conclusion that it's not seen a patent it needs to license, even under that patent by patent licensing stance. And I truly mean never ever. The judge goes on in para 206, and at the end of it makes this further finding. It says this aspect was an important part of Apple's negotiating approach. Can I ask my lords to note this paragraph carefully, because there are 3 important points in it. First, that what the judge is talking about when he's referring to patent by patent review is the ability to pick and choose patent by patent what to license and not to take the portfolio license. The second is he's saying Apple does it. And third, it's an important part of Apple's negotiating approach. The next paragraph, paragraph 207, is also important because the judge makes a further finding that it's generally the case that Apple tells counterparties that no license is needed and that every single set for which a claim chart's been provided is either not essential or invalid. As I alluded to just now, it's every single counterparty, every single set. So that's the 4th important point in this part of the judgment. The judge made a finding this is generally the case. And as we shall see, that's hardly surprising given the materials he was shown. Now, my lords, I must address what the judge says about the context he considers these need to be seen in, because he makes 3 points. In the subparagraphs to 207, you see, he says, first of all, he points out that implementers met with a licensing demand need to assess the quality of the portfolio. Perhaps, my lords, but that's not to address the aspect of the stance that is to assert they will only take a patent by patent license and may
So it's difficult to see how that could be assessed, say, by way of patent examination. What about sampling? To just take one random example.
Well, you could do. But the further point that I make, my lord, is it's just not addressing what's actually happening. It's assuming something else might be happening and not addressing. It's not addressing the aspects of the stance that is actually to assert they'll only take a patent by patent license and may force litigation and licensing on that basis. Now, this is, of course, a point that Apple sought to latch onto in its argument and seeks to distinguish from holdout. But with respect, just not addressing the position the judge has held to be the case and is describing. His second point is similar. The point is Apple frequently take a license without conducting a review of everything covered in the license. So the judge says it's a negotiating ploy. We totally agree it's a negotiating ploy. It's the blueprint for holdout negotiating ploy. This is really the point I referred to earlier, the argument that it's okay because Apple does in due course take a portfolio license. That is no answer, as I explained. And the third point here is the suggestion that an implementer like Apple is not likely to admit the validity or essentiality of a single patent, no more likely than a SEP owner would. The suggestion being made that it's not pointful because what's in issue is not a license to a single patent but a portfolio. And he goes on to suggest it would be different if Optis had offered a pick and choose approach. And once again, this misses the point. Apple is at the same time saying it can insist on a pick and choose approach and will force litigation along those lines. And by doing that, at the same time, it can avoid any Fran determination because it says no license at all is needed. And my lords will appreciate, I hope, that my complaint is not that some specific individual patent should be identified and accepted as valid and infringe. It's that they do not accept that any will be. And at the same time, they assert the contention or that contention, means that they do not need a licence and can force the patent by patent approach to litigating and licensing, which, as I've shown you, Apple knows full well means that its SEP owner cannot force a resolution. Contrast that to what I've said about a party who accepts they need a portfolio licence, submits to a determination if you're unable to agree. That can be done by accepting there are patents that will be valid as a general matter. It doesn't need a specific patent to be formally admitted. And we'll see more about this shortly. The judge then turns at para 208 to what he rightly calls a hard-nosed approach in negotiations with SEP owners. And he gives an example and sets out an example letter in paragraph 209. And it is a typical letter. In the third paragraph quoted, we see the same outcome we see in every other letter. Apple's concluded all the patents they are considering are not standard, essential and or invalid. And also one wonders how they came to court to argue the stack can be 20,000 or more. They did.
On this logic, it's 0.
Yeah. Anyway, just to point out, this letter refers at the foot of the page to the fact there are large numbers of patents and claim charts in issue with this negotiation. But as we've seen on this occasion, for the poor SEP owner, like every other occasion, Apple happens to have concluded that they're all not essential or invalid. Over the page 210, the judge points out that our case is that this evidence is holdout, which he says he'll deal with later. But at this point he goes on to say this: the attachments to the letter detail and evidence a good deal of hard work on the part of Apple. Indeed, although more likely by patent agents engaged by them. But my lord, that's nothing to the point. Intelligent holder-outers pursuing the blueprint for holdout, that is patent by patent, they know that they've got to do some work. But of course, importantly, that inflicts reciprocal work on often smaller counterparties, but the sums at stake make it well worth doing. It's naive in the extreme to think a company holding out doesn't realise they at least have to give the appearance of engaging in debate. My lords, the judge then moves at paragraph 211 to consider another aspect of Apple's approach to negotiations, and he sets out passages of cross-examination that is actually directed to Apple preferring a FRAND valuation to be done in dollars and cents, i.e. DPUs rather than ad valorem. I draw attention to it while we're just passing over it because you can see that's the distinction I'm addressing with Miss Muse. See, it's the first question, point she well understood, but it's another instance where the judge seems not to have understood this. He introduced it as directed to Optis insisting on ad valorem and Apple insisting on lump sum. It's just not what it's about. We can drop down to subparagraph 3 on page 346. This addresses Apple's incentives to pay less. You see that in the middle of the text of this subparagraph. Miss Muse said they had those incentives, but their goal was for there to be fair compensation for SEPs. And we can see what the judge thought of that suggestion. He accepted it would be concerned with how Apple might present, i.e. how it looked to others, but he found that it would behave first and foremost as a profit maximising entity. This is just before the indented text. Another important finding, we say. The judge went on in 3 subparagraphs, the third of which over the page is important for us. So I'm now subparagraph C in the top half of page 347 of the bundle. Apple would not allow altruism to override profit maximisation. And this relates to a further series of findings the judge makes. First, they do not seek out licensors and offer to license rights they needed. They waited till they were approached. Next, and this is absolutely key, my lords, they would not refrain from threatening patent by patent, territory by territory litigation in order to, quote, soften up their negotiating counterparties. Please note that important finding. This is most definitely not asking for a patent by patent review to assess value to attribute to a portfolio license that they're committed to taking. The judge goes on, Apple would be well aware such an approach, if carried out, was unlikely to be cost effective either for Apple or for the counterparty. It was a negotiating ploy, and one that Apple deployed in pretty much every case I've seen in this litigation. Please note that finding too, my lords. They did it again and again and again. And let me pause and just say this about cost effectiveness. It's quite understandable to say it's not cost effective for either side if you're looking at things as if both parties have the same resources and assuming it has to be carried out right to the bitter end. Every single patent litigated. But of course the reality is it will be much worse for one side or the other, so that they are, to quote the judge, softened up.
Yeah, but this is again where trial F becomes relevant, because the finding of Mr. Justice Mead, upheld on appeal, was that this factor was more prejudicial to implementers than it was to separate.
Sure, exactly, that's relevant as well. But also, the size of Apple, some of these businesses they're negotiating with are very substantial businesses, but they are not Apple. And they are being softened up to agree much more favourable terms, and to that degree, it is cost effective. Put another way, rational parties don't normally adopt negotiating ploys that they don't think are likely to be cost effective when viewed in this wider way. They're doing it precisely because this, in negotiation, is something that they do consider to be cost effective. Anyway, let's read on in this very important subparagraph. The judge explains that Miss Muse was pressed on why Apple required Optis to go through the technical trials, A to D, and the judge holds, apart from suggesting that this was their right, she could advance no justification for Apple's conduct. So that's another aspect of the conduct in this litigation that they couldn't justify. Again, a very important finding. Now, before we look at the passage where the judge actually addresses whether there'd been holdout or not, can we look at one more thing in the judgment? Can I take you to page 365 in the bundle, so paragraph 245. This is the judge going through the evidence concerning each of the Apple licenses, including the cross-examination. And this is the Ericsson section. So it relates to the example we gave, my lords, in the annex to our skeleton. There's a fair bit of confidential highlighting, so I will tread carefully. In fact, there are two topics covered here that we can just pick up while we're here. The first topic that the judge covered is actually a point my friends have referred to in their skeleton. This is their paragraphs 10 and 11, rather euphemistically referred to as deal sculpting. And they specifically explain in paragraph 11 of their skeleton that if a licensor asks for certain terms to be inserted in the license that don't affect the underlying economics, Apple may agree to it. And the thrust of the point is that the term may be of no interest to Apple, but was requested by the licensor and agreed to anyway because it made no difference to the real economics. My lords, they're a bit coy about this in their skeleton, and the precise details are still marked in the judgment as confidential, or at least potentially so. Can I just ask my lords to look at the evidence quoted in footnote 352, bridging pages 365 and 366 of the judgment?
You'll do that.
It's about, well, that's eight or nine lines. So my lords, you can see what the term was in the first 3 lines of the quote, and my lords can look at that and assess how easy or hard it would have been to ascertain the unit royalty from that. And you can read on in the rest of the quote of Miss Mew's evidence over onto page 366 bit of it, still in the footnote, to see what she says about the clause not reflecting the underlying economics. And at the end of the quote, you see what Miss Mew says about what she believed as to why Ericsson wanted it included. Now, rather strangely, the judge seems to have missed the thrust of what was being described by Miss Mews as going on here. I say that because his reasons for concluding this was all above board is the reason he identifies in the text under the cross-examination on page 366. I'm afraid I don't know why it's highlighted as confidential, but as it is, I'm just going to ask my lords to look at that.
Yes.
You can read it and ask yourselves, is he focusing on the right party, given the description is of a term that's of no interest to Apple being sculpted by the licensor, i.e. Ericsson asking Apple to include a term that didn't reflect the economics? Now, my lords, you'll see that the thrust of the cross-examination set out here was me challenging Miss Mewes on her attempt to explain away this term and the reasons she gave, and what turned out to be a controversial characterisation of the thrust of her explanation. It doesn't matter for my appeal, but of course it was not my case that the clause was in fact a sham. It was my characterisation of Miss Mewes' explanation as to its irrelevance, and crucially what she claimed the true purpose behind its inclusion. Now, the judge identified 2 functions of licensing in the market over at the top of page 367. First, and most obviously, setting the terms of licensing relationships, but also secondly, to be seen as precedents to be deployed in negotiations with others. We see the latter function, he says, is in no way improper and not a sham. And of course, as a matter of generality, it's right. But the point was a much more narrow one. We were talking about an individual clause written in on Apple's explanation that simply did not reflect the economics of a deal done at the licensee's, at the licensor's request for the purpose Miss Mewes identified. So that's one topic that's dealt with here that I can pick up as we pass over it. The second section here, the top hole on page 67, deals with the peculiarity I referred to earlier as to why Miss Guttridge in fact took a different approach to unpacking the Ericsson licence. So it's the effect as to how they are paying a premium for the past compared to the future. It wasn't actually a free release unpacking at all and not generous to Optis, it was quite the opposite. And he deals with that from about the first hole punch on 367, setting out the cross-examination. But he doesn't resolve the issue, nor does he deal with the point as to how Miss Mewes could ever have had knowledge of the detailed matters she was purporting to explain. So that's the second issue that I can pick up while we're here. But that brings me to the section little Roman 3, and this touches on the correspondence we've addressed in Annex 3 to our skeleton. So if it's possible, can my lords have Annex 3 to our skeleton open also, page 132 of the bundle. So open with the judgment. And the first extract that's addressed in the text of the judgment at 368, the foot of the page, and over to the top of the next page, is the first letter addressed in paragraph 3 of our annex. One sees the substance of the introductory wording is captured in the first 2 questions, the essence of which is Apple says it will enter into a license if presented with a true friend offer. I pause to remind Ms Muse this is the same time frame as the policy of opportunistic licensing that we've seen in the internal documents. So I suggest to her that this is not entirely frank. She disagrees. At the top of page 370, we move to the next part of the letter attacking Ericsson's portfolio. After referring to the loss rate of 90% generally in set cases, which I might add makes our success rate in this litigation look rather brilliant. The paragraph that's referring to this is followed by the last part we quote in Annex 3, the statement that as of that point in time there had been no determination or proof that Apple products practice even a single Ericsson patent, which I put to Miss Muse through the rest of the quote in the judgment at 370. I characterised the paragraph as suggesting that there's not a single patent that Apple is practicing, and the judge intervenes. His point, I think, is because of the words no determination or proof. And if we go over the page to 371, I put the point again, Apple is not accepting that even a single patent was being practiced and that it was all being disputed. That's the second question down on 371. And the answer is this, that in context they were making a very substantial offer, but not a single patent had been proven and tested. I asked again, Apple was taking the position it was disputed whether or not a single patent was being practiced, and asked if they honestly believed it. The answer is the same. There's been no determination that Apple practice even a single patent. Well, before we look at the way in which the judge says you can look at this, can we look at the way the correspondence developed? We can take it from the annex in our skeleton, although if you'll note the full letters are at tabs 21 to 29 of supplementary bondle 2, although I noticed that one was accidentally omitted, and we'll arrange for that to be provided for completeness. But for present purposes, I can take it from my annex. Para 4 on page 132 is extracts from Ericsson's response. I won't read it out. You can see what they say about Apple's characterisation of the negotiating history. You can see what Ericsson think about how Apple has been negotiating since they started and how long it's been going on. The last 3 lines refer to matters as to Apple's strategy that we've also seen. Over the page, paragraph 5 refers to how both sides have ramped things up. It draws attention to a very big difference between them as to what they were intent on doing by that. Please read what Ericsson say, particularly that second paragraph quoted in paragraph 5 of the annex. Yes. I see the time. If you give me another couple of minutes, I'll get to the end of this annex.
Yes.
That request is absolutely key. And please remember Lord Kitchen's dicta as to what implementers must do. You can see what happens or what doesn't happen. Paragraph 6 sets out another communication from Ericsson. Look at what's referred to in the last 4 lines and what Apple's attitude to those matters were. Paragraph 7 of the annex focuses on what Apple's position was as to what Ericsson needed to prove. The first paragraph in particular is important, and we see in the final paragraph much of the rest of Apple's set policy is parroted. Over the page, please take note of precisely what is suggested at the end of the quote just before paragraph 8. So just above paragraph 8, look at what they're saying and ask yourself, is this licensing of the portfolio or the blueprint for holdout patent by patent determination? Paragraph 8 deals with a dispute about a need for more claim charts, and paragraph 9 is really key. Look at what Apple refused to agree. We'll come back to how that was dealt with in cross-examination after short journey.
In which case, 2 o'clock.